Hello, and welcome to the LLG Grapevine podcast. You're listening this week to Dennis Hall, LLG Bulletin Editor. And yes, it's just me this week. And this podcast must surely and rightly begin with the words to acknowledge the sad passing of our sovereign Queen Elizabeth II, a monarch whose commitment to public service and her sense of duty were unparalleled in public life. We share in mourning her loss, and our hopes and wishes are with the new sovereign, King Charles III. We are truly living through a turning point in our history, in a period of changing events that was already remarkable for other reasons. The appointment of yet another new Prime Minister, another new local government minister, and a team of new law officers. So let's take the opportunity now to do something of a reset and look back over recent bulletins that were posted on the website but not distributed during the period of mourning. A number of local government stories caught my eye over the last few weeks. One in particular involves the increase in the number of government interventions into the running of local authorities. Those interventions are definitely on the increase, but they leave many important unanswered questions about the direction and impact of government policy. By far, the vast majority of councils are well run. They are run very responsibly, and many are rightly proud of their excellence in innovation and in supporting their communities effectively through the most difficult challenges. The pandemic proved this beyond all doubt. But make no mistake, councils are struggling. The majority are buckling under the financial pressure brought about by inadequate government funding in the face of increasing demands for their services. There are new demands too. There's the ruinous cost of living crisis, and of course the expectations of the flagship policy of levelling up. But independent analysts have already concluded on the latter that, while levelling up is an admirable policy in itself, without adequate funding, it is no more than a hollow gesture. It is in this context that we are seeing more statutory interventions, more demands for assurance reviews, and lesser, more informal interactions between government and councils to sort things out that are perceived as going wrong, or that have gone wrong already. Thurrock is the latest in a lengthening list of councils where interventions have been announced. The list includes Liverpool, Slough, Nottingham City, Northamptonshire, Tower Hamlets, Rotherham, Sandwell and Doncaster. There's a second list of authorities too, where assurance reviews have been demanded. Bexley, Copeland, Eastbourne, Luton, Peterborough, Redcar and Cleveland and Wirral. Croydon has also attracted government attention in recent months. But the reasons for those statutory interventions, however, are diverse. Most concern finance and governance issues, but exceptionally they include children's services and electoral fraud. In some cases too, the cause has been an overzealous embrace of the government's encouragement of commercialisation and property investment. So the government's hands are not entirely clean when it comes to their own role in all of this, especially and more generally in their myopic vision in regard to local government finance. Sometimes the intervention comes as a prelude and a recognition that a council has reached a point where it can no longer pay its way, and massive injections of emergency funding are required. But my point is this: where is the analysis of the government's role in all of these cases? And is statutory intervention capturing the whole picture? The Secretary of State's legal powers are contained in Section 15 of the Local Government Act 1999, part of the best value regime, legislation that predates these interventions by over 20 years. Before 2012, these interventions were unheard of. It's strange that, isn't it? And now, further government involvement, as opposed to full intervention, is provided for in Clause 71 of the new Levelling Up and Regeneration Bill. This provision amends the Local Government Act 2003 by enabling the Secretary of State to issue risk mitigation directions to English local authorities for the purpose of reducing or mitigating the financial risk to the authority. Now, the Local Government Association has said it is deeply concerned about this new wide-ranging power, which could see directions requiring local authorities to limit their borrowing or even to divest themselves of specific assets. Given the context that I outlined at the beginning of this piece, these new measures are likely only to make bad situations worse. These new powers seem more like interference, not intervention, more like a punishment rather than an attempt to repair damage. But what these intervention mechanisms simply fail to do is to properly assess and grasp the government's own role in all of this. The inadequate funding of local government is a contributory factor in all decisions concerned with the allocation and use of resources by councils. All commentators agree government is not entirely blameless. Years of austerity and now a cost of living crisis after the pandemic. Those lists I referred to can only get bigger and bigger. Another item that stood out was the announcement of the land registry plan to go fully digital by 2025. From time to time, it's important to look beyond our sector in order to take a look at the wider picture, to see what eventually might influence how we do things differently in future. Now, the way we do property transactions is about to change dramatically. Secure paperless buying and selling of property could be the norm by 2024 to 2025, HM Land Registry has suggested in its latest strategy for end-to-end digital conveyancing. The aspiration appears in the agency's Strategy 2022 Plus and its 3-year business plan. Announcing the strategy, the registry said it is inviting first the UK property sector to work in partnership to create a simpler, paperless and transparent process for buying and selling property, which will benefit homeowners across the country. Work will include a significant investment to enable the end-to-end automation of up to 70% of all updates to the register by 2025. Automated applications will be completed within 1 day. Many of them in seconds, the strategy says. The registry also will encourage the market to adopt new technologies such as digital identity verification and e-signatures, which are seen as essential to the paperless process. For the land registry, that means a step change in their offering to customers so that they can receive a fully digital service. Now, it is this idea of a full digital service that attracted my attention and the short timescales involved in the announcements. Not because this is a surprise in itself. Indeed, it was always inevitable that this would happen. But my question is whether councils have or are already investing in the necessary digital infrastructure for them to play their part in all of this. I'm less certain of the extent to which councils currently embrace the use of digital identity verification and e-signatures, for example. Every day, councils engage in transactions with the land registry on an enormous scale. The investments required will be massive. LLG will keep you informed on how this initiative develops. Local government needs to be at the top table on this one. I turn now to the world of politics and the law. New Prime Minister Liz Truss has acted very quickly to withdraw proposals for a new Bill of Rights. Most commentators welcomed this news. Truss told the Cabinet that her government would reassess ways to deliver its agenda in this area. The bill was the flagship policy of the outgoing Justice Secretary, Dominic Raab, who was dismissed by Truss a couple of weeks ago after backing her rival Rishi Sunak in the Conservative leadership election. The sudden disappearance of the bill will raise questions over how the government intends to proceed with its Rwanda deportation policy, which is in limbo after the European Court of Human Rights issued last-minute injunctions to prevent asylum seekers being sent there. But the bill, which was in the Conservative manifesto originally, would have given legal supremacy to the UK Supreme Court and make it explicit that UK courts can disregard rulings from the ECHR. Now, critics had argued it would not materially affect the UK's relationship to the European Court and was unlikely to lead to a resolution to the current impasse. A Whitehall source said there were issues with the drafting of the original bill, describing it as a complete mess. I don't disagree. It was wrong for a lot of reasons. I turn now to hybrid working. A district council has agreed to set up a pilot scheme for a shortened week for 470 desk-based employees. A Cambridgeshire council has become the first in the UK to trial a 4-day week in a pioneering test of whether the working pattern can be applied successfully in the public sector without disrupting frontline services. Councillors at South Cambridgeshire District Council voted to pilot a shortened week on the same pay for 470 desk-based workers before possibly rolling it out to bin collectors at a later date. Workers who process benefits claims, collect council house rents, process planning applications, and carry out environmental health inspections would work 30-hour weeks for the first 3 months of 2023. Service performance will be monitored, and the council said the trial would become permanent only if there was no drop in standards and there was an improvement in staff well-being. Refuse collectors have been left out of the initial trial because of the difficulty of emptying the same amount of bins in 20% less time without adding staff. They may be included later next year. Now, the move to follow dozens of private companies in attempting a shortened week has been prompted in part by a recruitment crisis, blighting councils across the country, with years of relatively low pay in local government deterring applicants. Between January and March, only about half of South Cambridgeshire's vacancies were actually filled. More than half of councils in England and Wales report having insufficient staff to run all services normally, according to the Local Government Association. Staying with that wider picture once again, as I said, we have yet another new Prime Minister. So what about the law? What lies ahead for us? The Law Society Gazette say that Liz Truss will have an opportunity to reset the government's approach to the rule of law and address the crisis in the justice system. Law Society President I. Stephanie Boyce said, "We call on the new Prime Minister to demonstrate a renewed respect for the rule of law at home and with international partners when she takes office. The withdrawal of the Bill of Rights will come as welcome news to the Law Society." Boyce also said that the justice system is facing a make-or-break moment, with huge backlogs in the courts, delaying justice for victims and defendants. There are even wider issues, of course, left over from the previous occupant of number 10, the need to respect the judiciary and for the role of lawyers, and I might add, the need to be driven by a strong set of ethics, something that has been absent for a long while. Well, on that note, that's it for another edition of the podcast. You can read some of the bulletin news that you may have missed over the last couple of weeks by going to bulletins 33 to 35, available now on the LLG website. So it's goodbye from me for this week, and thank you for listening.